We are now ready for our next speaker, which is attorney Keyonn Pope. And he's from out of Chicago, and we're hitting his sweet spot, as he told me the other day, when it comes to trademark law and copyright, U.S. copyright law. Okay, we're ready.
Oh,
Okay.
thank you. Can you all hear me okay?
We got you loud and clear, Shout Town homie. Let's do
Oh,
it.
fantastic. I see the Bears. Go Bears.
Hey.
Hopefully they'll do what they're supposed to do. But appreciate you all having me. It's a joy to be here. As she mentioned, my name is Keyonn Pope. I am an attorney at the law firm of Riley, Safer, Holmes, and Cancilla. I'm based in Chicago, but our firm is five offices. We're in Chicago, New York. We've got two offices in California, and then an office in Michigan as well. But we're a full service national firm and service clients and handle matters all across the length and the breadth of the U.S. and even some touch points internationally as well. I've been doing this for a little over 15 years now here at RSHC, as we call it for short. I lead our intellectual property practice, and I primarily litigate and try cases related to intellectual property. I'm a proud husband, proud father, and relevant to this group since it's D9. I'm also a proud member of Alpha Phi Alpha Fraternity Incorporated as well. In terms of representative clients, my clients run the gamut. I'm sort of industry agnostic, but again, relevant to this constituency. For the last, I don't know, 8 or 9 years, I've been the primary outside counsel for Sigma Gamma Rho Sorority Incorporated, and had the pleasure of working with them on a myriad of legal and strategic issues and advising their board, et cetera. But other clients that I either currently or have done work for include the likes of major brands like Hershey or Nintendo, Blue Cross Blue Shield, Honda, Kia Motors, and even I do some media and entertainment work. I love music, so that the estate of Thelonious Monk. I have some clients in the gospel music space, Maurette Brown Clark, Anthony Brown, etc. But that is just to give you a feel of some of the work I do and what I do, who I do it for. Um, I want to talk a little bit. We hear the term IP or intellectual property all the time. Let's see if I can share my screen here. Um, Figure out how to do it. Well, anyway, I'll just talk. I've got a few slides, but I want this to be interactive and participatory anyhow. But we hear the term intellectual property, and I want to spend a few minutes sort of setting the table on what intellectual property really encompasses. I know our focus is trademarks and copyright, so I'll spend the bulk of the time talking about those. But IP or intellectual property is really an umbrella term that encompasses a number of areas. Obviously, trademarks, copyrights, but patents is included under that IP umbrella. Trade secrets, and then you can also sort of include, the right of publicity, meaning the right of one to monetize and control the use of their name, their image, and likeness. You hear a lot of that now in the collegiate sports realm. And I'll throw another one in there, domain names as well, given how much of commerce is web based nowadays. I'll run through each of those and just kind of talk about the interest that is protected, how you acquire said rights, and for each of those, and whether registration is required. So for trademarks, trademarks are really a consumer-based protection. Is to prevent consumer confusion. When you, it's intended to when folks see encounter a logo or a slogan or even a sound or a smell, all of those can qualify as trademarks. They know that when they see whatever that indicia is, that it brings to mind a certain source. So you see those golden arches, automatically you think McDonald's, or if you hear "I'm loving it," you think McDonald's. And that's key, right? Is to prevent consumers from being confused. If somebody else started using the golden arches, and you pulled in, and the fries were different, you would be disappointed. And so to avoid that, you've got trademarks that protection and trademark rights that have cropped up. You can imagine, fries being different is not the biggest deal, but imagine in a healthcare context where you've come to know and trust Bayer aspirin, and somebody else begins to use the Bayer aspirin logo, and they're at home on in their garage whipping up what they deemed to be aspirin and putting it in a bottle and using the Bayer aspirin logo. You could have some serious issues. So you can see the importance of trademarks. The way you acquire rights and trademarks is really by use. There's no requirement that you have a registration in order to have trademark rights. Now, uh, registration is strongly encouraged, especially here in the U.S. There's some additional benefits that you get vis-a-vis registering your mark. So, highly recommend that you consider doing so. But just by using a mark and it becoming associated with you and becoming a source identifier, you automatically have rights in said trademarks. It's sort of why you see sometimes you see the use of the R with the circle around it. That denotes that a trademark is registered. But other times you might see the little small TM, or you see the small SM. That means that mark likely is not registered, but whomever is owns that mark or is using that mark claims rights in it, just vis-a-vis the use as opposed to the registration. I'll move to copyrights. Copyrights are protect original works of authorship. So this could be anything from music to artwork, paintings, sculptures, photographs, etc. Similar to trademarks, no registration is actually required, but again, highly recommended. Tons of additional benefits that you get from registering a copyright. So just by at the moment that you create whatever the work is, and the law says you have to place it in a fixed medium, meaning it has to be in a tangible form, right? So you can't. It's not good enough to have the idea in your head sketched out in your mind. You need to reduce it to the computer screen, to a piece of paper, some tangible form. But once you do that, so long as it's original and it meets the requisite level of creativity, you technically have rights. You have copyrights in that work that you created. Again, tons of benefits for registering it, but you technically have rights just vis-a-vis having created it and reduced it to a fixed or a tangible medium. Uh, Patents, require a certain level of novelty and usefulness for whatever the invention is. You have three different types of patents. The most common is a utility patent, which protects the way an invention is used. You also have design patents, which protects the way an invention looks. You see those a lot, for example, in the automotive industry. The look and feel of vehicles and the shape of fenders or bumpers, etc. And then the third category that's probably even lesser known are plant patents, as well. Certain types of species of patents that folks may be, of plants rather, that folks may be coming up with. But these, unlike trademarks and copyright, patents, no registration, no rights, period. So you only get rights once you apply for that patent, and importantly, that the patent office grants you an allowance of that patent. Until then, you don't technically have any rights from a patent perspective. Trade secrets is another area. It protects anything that could give a business entity a competitive advantage. So this can be anything from client lists to presentations on certain processes, or it could be I always give the example of the recipe for Coca-Cola, or Bush's baked beans, right? There was an advertising campaign some years ago about the Bush baked bean recipe being so secret. That's an example of a trade secret. folks go the trade secret route because all the rest of those the other areas that I mentioned, so patents, copyrights, and trademarks, they require you to disclose whatever it is that you're looking to protect. So for if you want a patent, you have to submit an application that gives all the details on what it is you're patenting. Uh, well, if you don't want to disclose what it is, trade secrets might be a route that you can go. If it's something that gives you a competitive leg up, but you'd rather not disclose it, trade secret protection is the way you go. There's no registration for it. So how do you acquire rights? You basically you have to keep it secret, right? It's called trade secret, so the secret piece of it is critically important. Once that toothpaste leaves that tube, it's almost impossible to put it back in, right? So you have to have certain safeguards and protocols, et cetera, in place to make sure that you're adequately protecting the trade secret and guarding it with your life, essentially. The last two, the right of publicity. Again, you hear buzz about NILs in the context of the collegiate sports a lot now. Again, no registration is required for NILs, although NIL or right of publicity could also cross over into the trademark space. And you basically, how do you acquire rights? By the moment you're born, you get a name, you look a certain way, and uh, as you go through life, and your name and image become more valuable, such that folks might want to use it, or you might want to use it to monetize. That's really how you acquire rights. An important footnote on the right of publicity: those can, in certain states, they can endure even after death. So you can leave the right of publicity in your estate, depending on what state you live in or what state you were living in at the time of your death. There's certain states that don't recognize it. For example, in New York is a state that doesn't recognize it, and there's several others. Um, but a really powerful tool. And then the last are domain names, which I'm sure all of you, being entrepreneurs and business owners, likely have web presence. So I don't have to spend much time there. But I thought it'd be helpful to just step through what all is included when you hear folks say intellectual property or IP. It's a broader umbrella and includes a lot more things than many people often think of. I know our focus is trademarks and copyright, so I'll spend a couple of more minutes talking about trademarks and copyrights, and then I'm hoping that the chat will begin to light up with some questions. They told me that this was a hot topic that you guys might are grappling with and dealing with, and so rather than you guys listening to me drone on, I would love to hear what's on your mind and steer comments and field questions based on that.
Oh,
Um,
let me ask one thing.
sure.
Are you, I know you said you had some slides. And just in case if you can't share them here, please send them to me so I can include them in the finished product. But is he able to share his screen if he needs to, Eric, at this point?
Yeah, he just needs to go ahead, and there's a share button at the bottom
I
of
see.
the screen. And when you share, you just need to share a specific window or tab.
Got it. Yep, I see it now. Uh, all right. Can you
Awesome.
guys see?
Hey, loud. Yeah, we definitely
All
got
right.
it. Nice.
So I won't belabor the point on this, but this is what I was just speaking to about the various types of IP and the comparison and what's protected, how you acquire the rights, and whether registration is required. Um, I'll talk a minute about trademarks. As I mentioned, it's a source identifier. So you see it, you encounter it, you think of a particular source for that trademark. As I mentioned, it can be anything, right? It could be a sound, it could be a smell. Even I think Chanel #5, for example, is that smell is and was so unique that they took the time to register it. as soon as you encounter it, you know it's a Chanel product. Or for McDonald's, I know they have the jingle ba da ba ba ba. As soon as you hear it, you think about uh, um, McDonald's. So it can be trademarks are broad. It can be anything that functions as a source identifier. Um, and again, the whole premise of trademark rights is to prevent confusion amongst consumers. What's the test for that? It's measuring how similar the marks are. So whether it's logos or slogans, etc., how similar are those marks? And then how similar are the goods and services that they're used in connection with, right? You have, let's say you have identical marks. One is used in the food space, one is used in the construction space, despite the fact that the marks might be the same, the fields are, and the goods and services are totally different. So you would have a hard time arguing that there's confusion. And then where and how the marks are used, right? Which will be impacted by the goods and services as well. Some examples of some famous trademarks. Some of these don't even have words, but these logos right away, I'm sure folks, it brings to mind immediately who is associated with said logos. Um, not all trademarks are created equally, right? So the strength of trademarks can vary, right? So on the left hand side, you've got generic marks where you can't have any protection. There's no protection granted for generic marks. And then on the other end of the continuum, you've got fanciful or arbitrary marks. So Apple for computers, for example, or Exxon, which was a made-up word. We all know it for the gas stations and oil refineries, et cetera. Now, but it was a made-up word until they popularized it. So when you're picking trademarks, when you're thinking of branding yourself, or you want to keep this continuum in mind and make sure that you're in on the proper end of this continuum as you select your marks. Um, you know, more examples of different types of marks, right? You have word marks on the left, and then logos on the right. Um, you know, this I borrowed this slide from a presentation that I did for the MPHC, but consistency matters when you have trademark use. We have, sometimes we fall into the practice of sort of altering marks. We'll begin to use it one way, and then over time we'll sort of evolve or put our own little spin on it. That's fine. Just be cognizant and be aware that could have implications in the rights on the mark. The way that you register a mark it's sort of fixed, right? And if you make what is deemed to be a material alteration to that registration, to the way that the mark is presented, it could impact the rights that you have in the mark. So that keep that in mind as well. I see. Thank you for the question, Ms. Jackson. You asked about 1913, 1908, and some of the other founding years of Divine Nine organizations. Absolutely, those can function as trademarks as well. I know for a fact some D9 organizations already own registrations for their founding year. And remember, I said earlier, trademark rights don't hinge on registration, right? You can have rights in a mark despite it being registered. Tons of benefits to registering it. So encourage you to consider doing so. But just the fact that it's being used, and when we in the D9 space see these years, it automatically calls to mind the organization that it's affiliated with, especially when the year is coupled with the colors or other indicia So absolutely, those can and do function as trademarks, and I know some of the organizations have registered those. Um, Christy, my Southern University classmate, thanks for the question. She asked if she said that I've mentioned repeatedly that registration is not required for copyrights and trademarks, but it's recommended. How can one identify designs, ideas, slogans that are copyrighted or trademarks? And what if not registered? Do I still have liability and damages if I use it unknowingly? So, great question. I'll take them in turn. How can you identify designs and other um, works that might be copyrighted or trademarked? So both the Copyright Office is housed in the Library of Congress, and the Trademark Office has its own office combined with the Patent Office, so the USPTO, the Patent and Trademark Office. Both have websites with repositories that you can search. Think keyword search similar to the way you would use Google or any other sort of search feature, and you can go in there and search for whatever it is that you might be looking for. Now, look, trademark registration and copyright registration has been around a long, long time. I mean, hundreds of years, 100+ years at this point. So you can imagine the repository is dense. There's a lot in there, and so it depending on what you're searching for and what the words are, you're going to get a lot of hits, and it can be a little unwieldy to search through there. And even if you do a great job and spend a ton of time searching in there, it's not going to be bulletproof. But they do have repositories where you can go and search and see images and see um, see marks and works that are registered. eh, to take the second two questions, what if a mark isn't registered? Do you still have liability and damages? Yeah, in the copyright and trademark context, you do. And intent really doesn't matter, right? You can commit copyright infringement or trademark infringement unknowingly, and the law really doesn't make allowance for whether you know or not. Now, the law does make allowance or may make allowance in terms of uh, it doesn't make allowance on whether you've committed infringement, but it will make allowance on the damages that you might be on the hook for, right? If you're deemed to have knowingly or willfully infringed, right, that's going to be viewed in a harsher light than if you did it unknowingly. And so the damages could be lower if you did it unknowingly, and accordingly higher if you're deemed to have willfully infringed. But yeah, it's what we call a strict liability infraction. There's certain things and that doesn't really matter. If you're speeding, speed limit's 55. If you were going over, it doesn't matter. Maybe the officer will have mercy on you, but it's not a defense that I didn't know, right? You should have known is what they will say, and again, the penalty may be harsher or less harsh depending on whether you deem to have known or not. But great questions. Um, and please keep the questions coming. I throw this up. I talked a little bit about one trade dress, which is closely to related to trademarks, right? And trade dress is the look and the feel of something, right? Which is powerful. I had the question about 1913 and 1908, right? Uh, Perhaps 1913 would automatically bring to mind. Well, let me use 1911 because I know we have two organizations, right, that were founded in 1911, right? So if you throw 1911 up, depending on whether you've got more Kappas or Qs in your family, one might spring to mind before the other, but it could be either of those. What's going to really make you know? It's probably going to be other indicia, the colors, right, and that's trade dress, right? And similarly, this picture is trade dress as well. It doesn't have any indicia or anything on it, but I see in the chat, you already knew it was the Apple Store just because of the look, the feel, the layout of it. That's trade dress, and you're right, it is the Apple Store, even if I cover up everything. And that's another powerful tool, in the under the umbrella of IP. So I throw that out there as well. And similar to trademarks, no registration is required, although recommended, highly recommended. But just by using the trade dress and it becoming associated and affiliated with a source identifier, in this case, Apple, or in the colors of our beloved organizations, the colors being associated with the respective organizations, that's trade dress, and you have rights, and just by use and developing the goodwill in the use of those of the trade dress. Some examples of trade dress, you know, the LVs, the red bottoms for shoes, the red wax on the bottle of Maker's Mark, the red and white split label on the Campbell soup, the distinctive color of the Tiffany blue box. I mean, it's got its own color name for the box, for the color that they use, the color of blue, Tiffany blue, right? All these are examples that pretty much right away we would be able to identify most or all of these, even if you covered up the names, right? If you covered up the name on that Tiffany box, I bet that you all would have guessed, or known that it was Tiffany's, and that's trade dress. Um, so again, it can be broad. This is language from a famous court case that sort of helps solidify um, the rights around trade dress. But it could be broad. It could be anything, on packaging, websites, buildings, the layout, the exterior, the interior. All of that can be protected when you think about trade dress. Again, it's the total look and feel of something, that makes it, as we say in the legal world, distinctive. See another couple more questions. Ms. Dixon, thank you. How do I protect designs that I create? I created several designs. Do I need to copyright them or trademark them? How do I protect designs using D9 copyrighted images? So, um, oh, protecting designs, I'm assuming you're asking specifically in the context of paraphernalia that you're creating for D9 orgs. It's probably going to be um, copyright, because I see in the next question, there's a call out that, as vendors, you license the use of the marks from the org, right? So they grant you the right to use the marks, but they don't sign over ownership, right? So you wouldn't be able to take your designs and trademark them, right? But your creative spin that you put on, incorporating the founding year, or the colors, or the various shields, or whatever other indicia, right, that brings to mind these organizations, you can very well protect those via copyright. Um, so absolutely. Now, look, I've worked with vendors, and I mentioned earlier that for the last several years, almost a decade now, I've worked with Sigma Gamma Rho, including in connection with their vendors, right? So I have a feel for you all's business, and I know that you probably have dozens of designs, right? What does that mean, right? From a practical perspective, uh, you know, you may not be able to go and protect every single design, right? Either you don't have the resources to do it, or it wouldn't be a wise investment of the resources, right? Or you don't have the time to do it. There's some practical constraints, right, around being able to do that. But certainly you're more, as you think about your portfolio of designs and ones that are your most popular, your best sellers, absolutely, you ought to go and consider copyrighting those. The other thing I'll mention, a practical tip, is as you think about copywriting, there's a way where you can sort of uh, copyright works in bulk, right? So think if you're a songwriter, you might have 50 songs, and to go through and pay the $100 or whatever the fee is, for each of those, that could add up pretty quickly and become cost prohibitive. But there's a way for you to take all 50 songs, bundle them together, and sort of register the catalog together, and then you could take a similar approach for your designs if that's sort of a loophole to a more cost effective way of doing it. But look, I would encourage you to go through your portfolio of designs, and especially the ones that you can identify that are more popular, are your best sellers. Yeah, consider copywriting them. And yeah, hope that answered the question, Ms. Dixon. If not, please follow up in the chat. Ms. Landrew, we license to use the marks of orgs. What can or cannot be claimed or registered for our designs? So let me take that piece. So yeah, you can, because you have a license, right? You can take you can put your own, again, artistic spin on or artistic interpretation on designs, even if they do incorporate the D9 symbols. You can't copyright or trademark the symbols themselves because they belong to the organization, right? But you can take your design and your interpretation and your creative spin and copyright that. So, but to be clear, that the copyright would be on your interpretation of the use of those marks and not on the marks themselves, right? Um, it goes on to say, some feel we can use almost anything designed and distributed because it is the IP of the org we license for and don't recognize the unique design elements. Yeah, no, that last piece is problematic, right? If you as a vendor, as a designer, as an artist, if you sit down and put pen to paper, or even if you hire somebody or you're using AI tools or however you come up with these creative designs, and they're unique enough, and they meet the requisite level of creativity for in copyright law. No, I mean, no, somebody can't just come along and use that. And I know from a practical perspective it can be challenging to sort of police every single place and such where that might be happening, but it is problematic. It does begin to encroach and tiptoe into territory of infringement, and yeah, you ought to be mindful of it. I'll highlight that the Copyright Act is you know it has very interesting and stringent direction on damages, right? And again, it doesn't matter whether you intended to do it or not. Um, there's a range that they say you can be on the hook for copyright infringement, and it's per infringement, right? So, what does that mean? It means that if you knowingly or unknowingly take somebody's design and you use it, and you're deemed to have infringed, and you made you know 10,000 of those designs. You've got 10,000 brooches or 10,000 t-shirts or a combination. um, it's the damages, whatever that damages number is, times the 10,000. So those damages can rack up pretty quickly, in addition to if the case had to be litigated through through a trial and to a verdict. um, you know if you're found to have infringed, you can also be on the hook for court costs and attorney's fees, and those alone can be in the hundreds of thousands, and even in the millions of dollars. So I mean, this is serious stuff. The damages, for having infringed alone can be serious, because again, each individual piece that was created is going to be viewed as an individual infringement and multiplied by whatever the damage is. Plus, you could be on the hook for court costs, attorney's fees, etc. So it's serious.
I have a question, Keyonn,
Sure.
and I hate to interrupt you because I see a great question by Carol Jackson as well. After
Sure.
so you can copyright the artistic design of something that's already trademarked. Let me know if I'm saying that wrong, though.
No, you're
Design, the interpretation that you put on the IP. So you can copyright the artistic design of your interpretation of the IP that's on loan to us, like, the symbols or the other.
absolutely.
Okay. So that's something that a lot of vendors need to be cognizant of as well. And I could not find the right word to use prior to you just stating it. It's the design, it's the artistic design or the interpretation of it. So I look at Christie's pieces all the time. They are beautiful. And I can't just go in and say, well, she's using Delta Sigma Theta symbol, so I can just use that whole design. Actually, that is her artistic interpretation or her spin. So it's not right for me to do that. So that comes to a matter of professional courtesy or professional integrity. And I can't say I didn't know, like you just said. I unknowingly did it. So maybe that's something that we do need to look at as vendors, that it's the artistic design that some people are taking, and then they want to cry, oh, I'm sorry later on, or I didn't know, or try to use the defense. Well, it was the organization's IP anyway, and so I was not wrong in doing it. Maybe we need a style book. Maybe we need a style book of who has this style, who is known for this style or whatever, or this is their niche style. I'm not sure if I'm using the right terminology, but I'm glad you brought that up. And I see that Carol had a great question, and so did Chrissy. I think Chrissy just put something up, but never mind. Keep on going.
No, but appreciate that. Ms. Jackson, thank you for the question. You asked me to talk about the manufacturer's role in copyright. That's it's tricky, right? So most manufacturers, or many manufacturers, I'll say, um, they will they're not really concerned as much about you know they're in the business of manufacturing. They don't really care what it is that they're manufacturing. They don't concern themselves necessarily about whether you have the rights or not. And many will have, when you enter into contract with them to have them supply and manufacture, there'll be language in the contract that will essentially, they'll ask you to attest and affirm um, that you have the rights, the IP rights, and whatever it is you're asking them to produce. Either you have them by way of having created the piece yourself, or having licensed the rights from someone else. And so and that language is in there. And there'll also be additional language often where they will ask you to what we call indemnify, in case someone comes knocking and does file a suit that includes the manufacturer, right? In other words, you will have to be responsible for standing in their shoes and defending the suit on their behalf, because again, you gave the affirmation that you had the rights and the IP, right? So most times you will sort of see manufacturers try to distance themselves from any IP related quibbles, and they take the position that we 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 manufacture. That's what we do. We're in the business of manufacturing. We respect everybody's IP, but we don't get in the weeds and ask for, you know, proof of all that. And the law doesn't require us to do that. And by the way, you can see in our contract, we ask the vendors or the customers to attest that they've got the rights, and they indemnify us if something goes awry. So that's usually the position that they take. I see Ms. Dyson puts indirect versus direct infringement, and that's a timely call out. You can be on the hook. Manufacturers could potentially be on the hook if they're deemed to have known or should have known that something that they were manufacturing um, uh, it is infringing, right? So there are tons of cases out there where third parties have been deemed to be sort of vicariously liable for infringement. One of the cases that spring to mind is a case that was from here in the Chicagoland area. There used to be a famous flea market called Swaparama here in the area, and it was rife with people selling knockoff anything you pretty much wanted, and it had been called to the attention of the owners and the operators of the flea market time and time again, and eventually someone had enough. I think it was Harley Davidson had enough, and sued not only the vendors but sued Swaparama and its ownership as well, and they won and were able to hold Swaparama uh, liable because they could no longer say that they didn't know. Like, no, you knew because we told you, and you still didn't do anything to stop it. Therefore, you were vicariously liable. You were negligent by contribution, by turning a blind eye. So manufacturers could be on the hook that way as well. I'll say one more piece about the manufacturer. I see Ms. Jackson's comment that unfortunately there's no discussion of that nature. Look, when you have to be careful, certain manufacturers in particular from certain jurisdictions like in East Asia, etc. You know IP rights are a little more loosey goosey, and they tend, they may or may not respect IP rights, right? And so they don't care. They won't ask you those things, to Miss Jackson's point, right? And so um, bottom line, you can't bank on a manufacturer to a tip you off if you're bringing something to be manufactured that might be owned by someone else, and b, you can't depend on them to do the same to someone else who might be looking to manufacture your creative designs, right? And they'll do everything that they can to absolve themselves and keep themselves at bay and at distance. um, Mr. Tucker, I see your question. Should manufacturers be licensed? Maybe. I think manufacturers, again, they're going to take the position that, look, we're not the ones, you know, taking these pieces or to the marketplace, right? So why do we need a license? Our customer is the vendor. It's the vendor that's ultimately selling the wares in the marketplace to the end consumer, not us. So we don't need a license. I think that's the
Maybe some of us need to say no because that could have came from a fellow vendor a year ago, 6 months ago, 4 months ago. I may only use you for my original stuff, and I might have to come into that type of situation knowing that they might sell my stuff. So I'm going to make my money as soon as I can because I don't trust them. But maybe a lot of us do need to exercise professional integrity and professionalism or honesty when an overseas manufacturer comes to us with already made stuff that it may have come from a fellow vendor and just saying no. I hate to use the Nancy Reagan stuff, but maybe we just need to say no. No, not to that design. Let me come up with my own design. And in the back of my mind, I already know he's probably going to sell my stuff maybe after he's made my order, fulfilled. Maybe that's something that we have to consider.
I'll take this last question from Ms. Landrew about enforcement options, and then I'll make sure you guys get my contact information. We'd love to continue the dialogue or field any questions even after this. But enforcement options, yeah, I mean, look, cease and desist letters are a good tool to have. You could certainly draft yourself. Sometimes having a letter go out on an attorney's letterhead will have a little more teeth to it. So consider that. Um, you know, again, you'll figure out based on the circumstance whether it's one that you should send yourself or engage somebody to help you send. But those are good deterrents and good ways. Again, I know you all are busy running a business, and this is another time suck on trying to transact that business. But policing your designs is an important part of um, the continued vitality of your business. So cease and desist letters are good. If you see the your designs online offered, another good way could be, and especially if you have registrations protecting your designs, you can find out who the host company is for that website and send them a letter. Basically saying that you see on xyz.com that they're selling paraphernalia that infringes on your designs. Tell them the registration numbers, attach a copy of your certificate for your registration certificate, and request that they uh, remove the website or the portion of the website that's selling your goods, right? And that puts them on notice and puts the host company, the domain host company, in the crosshairs, because if they don't take certain actions based on that notification, they could be deemed liable if you were to ultimately sue. So they take those pretty seriously, and I've had good success for clients sending those letters and getting things taken down as a result. And then look, nobody wants to litigate or file lawsuits. So I would say those are last resorts, but sometimes they're necessary. And that's the only way you can get justice or get the attention of folks. And so, yeah, small claims lawsuits that you might be able to navigate yourself or with an attorney if you decide, or even one of the benefits of having a copyright registration, a federal registration, and same thing with trademarks, is that you do have access to federal court, right? You have a federal registration. It then falls under the purview of federal courts, and you would have a hook to sue someone in federal court, which is that's one of the benefits that I sort of mentioned in passing of having a registration, and why I would recommend considering it, especially for your more popular and sort of go-to designs. Um, Facebook groups as well that facilitate sales. So Facebook is tricky. You could send a similar letter like I mentioned to Facebook as well and put them on notice, or you could put the owner of that group on notice as well. I've had some success, but you could imagine there are millions of smaller marketplaces within Facebook, and so they're up to their eyeballs in these types of complaints, and so their responsiveness it may vary a little bit, but I've had some success usually on behalf of larger clients. I don't know how they will respond to smaller entities, but yeah, certainly worth a shot. Um, I'm mindful of the time, so I'll put up my contact information. If you guys have questions, my email and my office number is there. Happy to fill questions. Don't hesitate to reach out if I can be a resource. And wishing you all well and continued health, wealth, and success with your businesses and all the rest.
Hey, thank you, and we really appreciate that information. That man, there's so many layers to this that I mean, as someone seeking to purchase information, purchase items from vendors, as vendors trying to source materials that they do offer or distribute. Um, I think you touched on a very key point. There is a source, the U.S. Patent and Trade Office, that does have a database of protected materials, and it's it's really everybody's responsibility to go check that out before they get into the business of kind of distributing or manufacturing this. I mean, like you said, lack of awareness is not lack of liability, right? So, you can do research, and there are places where we can find that. So, man, great information.
Well, thank you all for having me.
All right.